Hola, muy buenos días, bienvenidas y bienvenidos a esta quinta sesión del conversatorio internacional sobre el test de proporcionalidad. Hoy es el último día de esta semana, así que cerramos con broche de oro con la conferencia magistral del profesor Virgilio da Silva. El profesor Virgilio Alfonso da Silva es titular en la Facultad de Derecho de la Universidad de Sao Paulo en Brasil y nos va a hablar sobre nos va a presentar una ponencia que se llama La proporcionalidad es más que la mera ponderación, el test de necesidad. Les recuerdo a todas las personas que nos siguen desde las redes sociales de la Corte y en la plataforma de las Casas de la Cultura Jurídica que pueden hacernos llegar sus preguntas en los iconos que están establecidos para eso en cada una de las plataformas. Y pues sin más preámbulos, con muchísima alegría los dejo con el profesor Virgilio da Silva. Virgilio, muchas gracias.
Muchas gracias a todos. Muchas gracias a usted, Diana, a la Suprema Corte por la invitación. Yo hablo solo un poco de portuñol, pero hoy voy a hablar en inglés. Tengo un poco, es más fácil. So I'll just switch to English. I hope you understand. It's a little bit, I'm a little bit ashamed to speak in English in Latin America, so I think Spanish and Portuguese should be the only language we should use. But sometimes for me it's easier to speak in English, and also because the presentation I'll do today is based on a paper that was written in English, so it's easier for me to speak in English. I hope you understand. And well, I'll start some presentation here. Just a minute. So, I think it's, you see the presentation. Okay, so, the title of the presentation is Proportionality is More Than Just Balancing, the Necessity Test. This means that this event in the Supreme Court, the Mexican Supreme Court, has not only one, but two presentations on the necessity test. So yesterday you heard David Bilchitz, who also spoke on the necessity test. So I think it's a world record. It's probably a world record. Two conferences on the necessity test in only one event. So it's a unique experience. And as I said, my presentation is based on an article that will be published, is still forthcoming. It will be published soon in the ICON Journal, International Journal of Constitutional Law. Here is the reference if you need it. The title of the article is Standing in the Shadows of Balancing, Proportionality, and the Necessity Test. It will be published, as I said, in the International Journal of Constitutional Law. And I begin this article with a kind of hypothetical dialogue. And someone says or asks, proportionality is balancing, right? Actually wrong. But those who read the literature on the subject on proportionality will most probably think that proportionality and balancing are just two different words to say the same thing. And then say, oh, all right, I think I read somewhere that in addition to balancing, proportionality also has other tests. I think they're called suitability and necessity tests, but well, you know, actually proportionality is really all about balancing, right? Actually wrong again, but it's not your fault. Although recognizing that the necessity stage is one of the steps of the proportionality test, that although this recognition is maybe textbook orthodoxy, there are so many articles and so even books written on proportionality that deal only with balancing and do not even mention the other prongs or tests, it's only natural that you end up thinking that proportionality is simply balancing. So, as I said, sometimes whole books are written on proportionality, and you have to carefully look at the index of subjects in the end of the book to find, if you're lucky, one or two reference to the necessity test. And when you if you find them, they are usually disappointing. Sometimes you get only one or two phrases on each of these tests, on suitability and necessity test. Of course, there are exceptions. For instance, scholars from Germany and from Latin America usually pay much more attention to the suitability test and to the necessity test. But in books, usually in books written in English, necessity test is, authors don't pay much attention to it. And why is this so? So in his book on proportionality, for instance, Francisco Urbina argues that only in trivially easy cases will the relevant question be the one addressed by the necessity test. Similarly, Sakirakis in his paper claims that it is always possible to argue that measures are suitable and necessary to accomplish a legitimate aim, and that proportionality is therefore reduced more often than not to balancing. Well, and we can also read things like this. As I said, the literature, especially that written in English, usually seems not to recognize an autonomous and relevant function for the necessity test. It seems to tacitly assumes what David Beatty explicitly states. According to him, although proportionality is commonly broken down into three distinct principles: suitability, necessity, and proportionality in the narrow sense, that means balancing, the first two are really just clear and easy application of the third. In my presentation, I would like to reject this view. I will argue that not only that proportionality is not just about balancing, but also that the necessity test has a much more important role than has been recognized so far. And this is not simply a question of terminology. I think that there's much more involved in taking the necessity test out of the shadows, so to say. The most obvious implications, surely theoretical or analytical. For instance, to make clear that, contrary to what Beatty argues, that balancing is not just, or the suitability and the necessity tests are not just clear and easy application of balancing. But I will also show that taking the necessity test seriously has other important implications for other ongoing debates around the proportionality test. So let me begin. As I said, the title of my paper is Standing in the Shadows of Balancing. It's a little bit different than the title of my presentation today, but the paper is called Standing in the Shadows of Balancing. And there are at least 4 situations in which the necessity test is put in the shadow. This happens by simply ignoring the test, claiming that proportionality is only balancing. Second, by conflating the stages of the proportionality test, means suitability and necessity are actually balancing, or a clear and easy application of balancing. Or by denying that the necessity test is part of the proportionality test. Or fourth, by mixing up the stages by means of an unstructured application of the proportionality test. In order to take the necessity test out of the shadow, so to say, in these presentations, I will present my views on what is necessity and what is not, how the necessity test works or should work, and present implications, analyze implications for the protections of rights, as well as for the relationship between courts and political powers. This is actually these are the backgrounds of my presentation. Well, the term necessity, as well as the term necessary, can be quite misleading. In the proportionality test, arguing that a given piece of legislation or a given state action is necessary doesn't mean that simply that something must be done, nor that the specific action was the only or even the best thing to do in this situation. According to the, so to say, canonical definition of necessity, a means is actually necessary if its goal cannot be equally well achieved by another means less intrusive to the affected right. So this is what I call the canonical, the traditional, the standard definition of the necessity test. So according to this definition, the necessity test entails not only one, but actually two questions, which should be asked and answered subsequently and not together. So suppose that the government adopts, or the legislature adopts, means M, the measure M, to promote the realization of one fundamental right. Call this right R1, derecho un. In order to promote the realization of the right 1, or R1, the measure M restricts another fundamental right. Call it R2. Okay. The necessity test then requires that the following two questions be answered. Question 1, is there an alternative means that is at least as effective as M, as measure M, in promoting the realization of the right? And question 2, if there is such an alternative, does it restrict the right to less than M restrict? If yes, then M was not necessary. So the assessment of the degree of effectiveness has priority, so to say, over the assessment of the degree of restriction. Assessing the degree of restriction is only relevant for those alternative means that are at least as effective in promoting the desired goal as the means adopted by the legislature or the government. So this is the canonical definition of necessity. I would like to illustrate this with an example. So suppose a hypothetical collision between two fundamental rights. It's in order to illustrate the application of the features and the outcomes of the canonical definition of the necessity test. Suppose that in a city called Proportionality City, some of the most important hospitals are located in the city center. The main street in the city center is the Necessity Avenue, which is a preferred location for political demonstrations. So if you want to do political demonstration, you surely want to do it in Necessity Avenue. Very well. When a political demonstration takes place on Necessity Avenue, there are traffic jams all over the city center. Ambulances, taxis, private cars transporting city sick persons need much more time to arrive at the hospitals than in other days. As a result, the health conditions of some of these persons that are being transported worsens. Some of them even die. All right, so after a long discussion on how to deal with this issue, the government of Proportionality City enacts a local law forbidding demonstrations on Necessity Avenue if these demonstrations block the traffic. The goal of this enacted law is to protect the right to health and the right to life and of the people that are transported to hospitals, and at the same time to respect the core of the freedom of assembly and political demonstrations. Demonstrations are not completely forbidden, only those that block the avenue. Let's call this measure M. This is the measure adopted by the government. Okay. Now, suppose that there are at least 3 alternatives to M. Alternative M1, alternative M2, and alternative M3. These 3 alternatives not only foster the same fundamental right, R1, the right to health, they also restrict only the same fundamental right, R2, freedom of assembly. Alternative means M1 is similar to M. It provides for a ban on demonstrations on Necessity Avenue if these demonstrations block the traffic, but only during rush hours and weekdays. So outside rush hours and weekends, there is no ban. Political demonstrations are allowed. Okay. Alternative means M2 provides for a complete ban on demonstrations on Necessity Avenue. It's completely forbidden. No political demonstrations on Necessity Avenue anymore. And alternative means M3 allows demonstrations on Necessity Avenue and provides for a special transportation scheme to other hospitals far from the city center. It only bans spontaneous demonstrations without previous note because the city administration needs time to organize the special transportation scheme. Okay, this is the situation. We have one measure decided by the government and 3 alternatives. For illustration purposes, let us assign numbers from 0 to 10 to express both the degree of realization of right, R1, the right to health, and the degree of impairment of R2, the freedom of assembly. So we could, this is the illustration. So it's possible to see this in this table. Each line is one measure. The first one is the measure decided by the government, and the other 3 are the 3 mentioned alternatives. So let's take a little bit time to analyze the table and the numbers, and then let's analyze it. Okay. The question is measure M necessary or not? according to the necessity test. So it's easy to note that neither M1 nor alternative M3 can be considered real alternatives in the terms of the necessity test, because they simply do not promote the goal at least as effective as M. They are less effective in promoting the goal of protecting the right to health. Only alternative M2 passes the first part of the test, because it's the only alternative that is at least as effective as M. Okay, only M2 is as effective as M, because M2 fosters the right to, with an intensity of 10. It's even more than 8. 8 is the intensity of the means M. Is the column on the right side. So alternative M1 and alternative M3 are less effective, should be rejected. Only alternative M2 passes the first stage of the test. But then we see that alternative M2, even if it's more effective than M, to foster the realization of the right one, it also restricts the right to more intensely, because it forbids actually any demonstration on necessity avenue, no matter whether the traffic is blocked or not. Therefore, it also fails as an alternative in terms of the necessity test, and as a conclusion, means M should be considered necessary. Okay, there's nothing actually new here, but we could think that, we could think that M, so the measure on the first line, is not actually the best solution for dealing with the tension between the right to health and the freedom of assembly. It's actually, M2 is also not the best one, even though M2 was the only alternative that passed the first step of the test. Actually, it seems that the best alternative is actually alternative M3, which didn't even make it to the second step of the test. This table shows you that alternative M3 is only slightly less effective than M in promoting the realization of right 1, 7 against 8. But at the same time, it is much less restrictive to the right to the freedom of assembly. It's 1 against 6. So why should we prefer M and not M3 if M3 seems the best solution? So even though the conclusion that M should be considered necessary means may be consistent with the canonical definition of necessity test presented a couple of minutes ago, we could still ask if it makes sense to stick to a definition that does not seem to help us pick the best solution. And this conclusion, necessity test, doesn't help us to pick the best solution, is the source of some objections against the canonical definition of necessity. I'll like to analyze very briefly 2 of them now. The first one is an objection presented by David Bilchitz in his article on the matter and in his presentation yesterday. David Bilchitz argues that, as you saw yesterday, and the canonical definition is too strict, because the assessment of the degrees of realization and restriction of the rights involved are carried out completely independent from one another. This means there is no overall comparison in which a cost-benefit analysis could take place. He calls this approach, the canonical definition, a strict interpretation of necessity. And he proposes a moderate interpretation of necessity, as you saw and heard yesterday. In his moderate approach, both variables, degree of realization and degree of restriction, should be assessed jointly and not subsequently. So instead of asking two questions, with the second question only being relevant if the answer to the first question had been affirmative, one should actually ask if one of the alternative means offers an overall better cost-benefit outcome than M means M. So we should assess an overall picture, an overall cost-benefit outcome. So according to him, this approach could avoid, say, rejecting alternative means that are clearly less restrictive to rights due just because it's a little bit less effective to foster the right one. In my example of proportionality city, such an overall cost-benefit analysis would probably justify choosing M3 instead of M. That means would lead to the conclusion that M was actually not necessary because the alternative means M3 is only slightly less effective than M in promoting the realization of the right to health, and at the same time much less restrictive to the affected right of political demonstration. That's why Bilges proposes a balancing inside the necessity test, as he explained yesterday. It seems interesting, but in my opinion, depending on how balancing or this type of balancing works, it may completely change the nature of the necessity test, and especially mitigate one of its most important features, that is the respect for the political process. If courts are allowed to strike down decisions or the means adopted by the government just because there is an alternative means that is less intrusive to the right to, even if this alternative is not as effective to foster R1, then I think that much great power is granted to courts to interfere in public policies than under the canonical definitions. I will return to these issues in a couple of minutes. Before this, I would like to present a second objection. Second objection is the objection raised by Kai Müller. According to him, there's almost always an alternative policy that is less restrictive, but almost always this alternative policy has some disadvantage. Either it's not equally effective, or it may require additional resources, or it may impose a burden on a third party, etc. What is implicit in this kind of criticism is that the necessity test is too narrowly framed, and therefore the means adopted by the legislature will virtually always be considered necessary. I think that this conclusion is based on the very defensible assessment of the utility of an interpretive tool, according to which a tool is only useful when its application leads to frequent strike down of legislation. In other words, I would say it seems to presuppose that whenever the adopted means is considered necessary, this means that the necessity test did not play any role. But I don't think this is correct. If an issue is submitted to a test whose result could be either approved or rejected, the test plays the role not only when the submitted issue is rejected, but also when it is approved. In both cases, the test played the role it should have played. An example may be useful here. If you are submitted to an exam at the university, for example, this exam actually plays its role not only when you fail the exam, but also when you pass the exam. So it makes no sense at all to say, well, the exam is only useful when people fail. No, it's also useful when people pass the exam. So this is a very actually short answer to this objection. In my paper, I discuss it a little bit more. So I think that many objections to the necessity test seem to assume that the task of the court is to find the best solution to each collision of fundamental rights. So if the necessity test doesn't help the court to find the best solution, then the necessity test is useless. What I claim is that there is no such thing as the best solution. So the court should not strive to find it. When the legislature debates over a new piece of legislation, for instance, several means to achieve its goal may be at hand. Each of these options, M1, M2, M3, M4, M5, I don't know, may be compared to its rival according to different criteria, such as efficiency in achieving the desired goal, compatibility with the Constitution, political opportunity, chances of approval, costs, popular support, possible side effects, among many others. So this is how legislature, a very simplified view of how legislature works. So legislative decision-making is thus constrained by several considerations: political, economical, financial, social, etc. But it's unconstrained, at least in one sense. It's not bound by a standard previously defined by a different authority other than the Constitution itself. In other words, alternative M1, M2, M3, M4, etc. are all of them equal candidates. The legislature will choose the means that, at least in that given time and context, seems to be the most adequate to fulfill its political will. But if the decision of the legislature is challenged before the court, the task of the court in the necessity test is not to choose or to point to the supposed best way to achieve a given goal, but to compare the means chosen by the legislature with each possible alternative. This means a comprehensive and unconstrained comparison among all alternatives may take place in the legislature, but does not take place in the court. The court compares one measure, that's the measure adopted by the legislature, individually with one alternative, a second alternative, a third alternative, but not, the court cannot treat all of them as equal candidates because one of them was already been was already been adopted by the legislature. It's precisely this distinctive comparative procedure of the necessity test that allows it to respect and take political process and political decisions seriously. Courts are not policymakers, so they should not be free to choose the policy that express their own priorities. They are there to control the decision, not to substitute the decision of the legislature. So this is courts may have or may prefer a different alternative and think this different alternative is the best one, but it's not its task to choose the best alternative, just to check if the alternative adopted by the legislature or by the government is necessary and proportional, not if it is the best one. So, this is the second part of my presentation now. Is there an autonomous and relevant role for the necessity test? And my answer is yes. I will only present, or actually present the outline of only two arguments. The first one is very easy. If there are measures that limit constitutional rights and pass the necessity test and don't pass the balancing test, or much more important, the opposite, in the opposite situation in which measures that could pass the balancing test but wouldn't pass the necessity test, then the necessity test has an autonomous role to play. It's just simple as that. I will illustrate that in a couple of minutes. So the first situation is a standard one. A measure passed the suitability test, passes the necessity test, but in the end, maybe fail or doesn't fail at the balancing test. Nothing new. But this leads many authors to emphasize that only the last test is important. The first two tests are not important, but they are. And if you consider the opposite situation, this will be clear. A measure that would pass the last test, the balancing test, if we jump direct to balancing, but would have failed the necessity test. That is, it would have failed if we would have done the job properly. So let me present a different version of my table. This is almost the same table I presented before, only the last cell is different. I changed it from 7 to 8. So alternative M3 fosters now the right 2 in an intensity 8. Means exactly the same as means M8. So suppose that means M, that is the means adopted by the legislature, is able to pass the balancing test, so the last step of proportionality, because it complies with the balancing rule. The greater the degree of restriction of one right, the greater must be the importance of satisfying the other. So if we jump directly to balancing, means M should be considered proportional and therefore constitutional. But it turns out that M is actually not even necessary, because there is an alternative means that equally fosters the goal, but is less intrusive to the affected right. This alternative in this new table is M3. Therefore, if we ignore the necessity test, as many like to do, we must accept decisions that we actually should not accept. As a result, it must be said that the necessity test has an autonomous role to play. It is therefore neither simply just a clear and easy application of balancing, as BT claims, nor it depends or collapses into the balancing test. There are measures that could be considered, could pass the balancing test, but would fail the necessity test. So the necessity test has an autonomous role to play. Nevertheless, I say we could, at least one issue should be briefly discussed here. In my example of the demonstrations on necessity avenue, when the table presented M as necessary, even though M3 was only slightly less effective than M, but at the same time, much less restrictive in relation to rights 2, this raised some doubts concerning the relevance of the test. Because according to the canonical definition of necessity, an alternative means that is only slightly less effective than M in fostering fundamental right R1 has no chances at all to be considered an alternative. It is simply rejected. This is why David Bilches proposed a different version of the necessity test, a version in which the different degrees of realization and restrictions of the rights involved are compared. In his approach, balancing takes place within the necessity test. I rejected this proposal here. Still, it's possible to argue that if two means should be considered equally effective, not only when they produce the same result, but also when they bring about results that are different but equivalent. So an alternative means should be considered equivalent even if it is slightly less effective. In other words, if the difference between both are irrelevant or negligible, there are no reasons not to treat them as equivalent. This is what I propose here: equality and approximation. A means should not be discarded just because it is slightly less efficient in promoting the same goal. If it's only slightly less efficient, we can consider it equally efficient, because no two means are really strictly equal. So that's why I propose a less strict concept of equality, in which the slightly less efficient means must be considered equally effective. So, but this raises, of course, the following question: what is the difference between what I'm proposing and what David Bilches proposed? Why is this not balancing? And I say it's not balancing because I'm not assessing the means. I'm not comparing degrees of realization and degrees of restriction. This will be balancing. And this is not what I'm proposing. I'm simply proposing another way of understanding the demand that in order to be an alternative, a means must be at least equally effective. In other words, I simply propose a shift from a strict concept of equally efficient to a less strict concept, according to which means that are only slightly different should be treated as equal. But no overall comparison between degrees of efficiency and degrees of restriction takes place here. I think I'm running out of time because it's a full screen. I cannot control my time very good. But I'll try to conclude in a few minutes. I don't know. I don't even know what time is it right now. Okay.
Vas bien de tiempo, Virgilio. No
tengo bastante tiempo, pero voy a concluir en 5 o 10 minutos. Muy bien. Again, I just want to analyze 3 issues: the relationship between necessity and time, necessity and politics, and necessity and scientific knowledge. It is so. Necessity and time. Consider this. 30 years ago, cars polluted the air much more than they do now. It was assumed that the benefits that the use of cars brings justify the pollution they cause. This is balancing. They pollute, but the pollution is justified by an increase in mobility, etc. Well, okay. New scientific knowledge may affect the result of this balancing. For instance, if we find out that pollution that cars cause affects our health and the environment much more intensely than we have supposed before. This affects the result of a balancing operation. Now we know actually the pollution affects our health much more intensely, so we have to do another balancing. But there are some types of scientific developments that do not affect the result of balancing test, but they affect the result of the necessity test. So they're really different things. Catalytic converters are a good example. Even if nothing changes in our knowledge about the effects of pollution of cars on our health and on the environment, the simple fact that there is a new technology that reduces emission of toxic gases without affecting other rights, this fact alone changes the result of a previous necessity test. In other words, what was in the past considered necessary doesn't pass the necessity test anymore. So the necessity test is a very good test or a very good filter where time, the effect of time may be analyzed. If there is some new technology that changes, reduces, for instance, in this case, the emission of gases, what was in the past considered necessary and passed the necessity test won't pass the necessity test anymore because of a new technology. Necessity and politics. Suppose the following scenario: in a highly unequal developing country, a given party wins the election and promises to put forward a very ambitious program to foster health, care, and education. Let's call this program Education and Health for All. In order to fund this program, a tax reform is also proposed, aiming at making the tax system more progressive and distributive. The majority of voters were convinced that both the tax reform and the Education and Health Care for All plan are the only effective way to minimize inequality and overcome poverty. The legislation that put those public policies and tax reforms into action is nevertheless challenged before the Constitutional Court. The plaintiffs, represented by the society, we are the country, whose members, not surprisingly, belong to the very best off in the country, are that there would be other ways to promote the right to education and healthcare, and that the tax reform that so intensely restricts the right to property of its member would not even be necessary. So they present an alternative plan for fostering education and healthcare, which changed almost nothing in the regressive tax system of the country. They argue that their proposed alternative is without any doubt the best means to accommodate all the interests and rights at stake. As you see in this table, an important right such as the right to property is barely restricted, and the rights to education and health are nevertheless substantially fostered. That's what they claim. But we can also see not as effective as the government wants. Is this an alternative in the terms of the necessity test? No, it is not. Even though the restriction in the right to property is less intense, the realization of the rights to health and education is also less effective. The court should not choose what it thinks it is the best solution, because, as we already know, there is no such thing as the best solution. Sometimes we must accept priorities defined by the government. We should test and we should analyze if they are necessary and proportional, but we should respect the priorities. That is a statement of the necessity test. And third, necessity and science. Consider the following questions. Are there any alternative to stem cell research, or to the criminalization of drug use, or to end-to-end encryption, or to the criminalization of abortion, or to affirmative action, or to social distancing in a pandemic context, or to border control, or to bank secrecy, and to use of pesticides, etc. These are only a few questions that may be asked within the necessity test. They emphasize the importance of knowledge from other areas, such as genetics, criminology, public health, computer science, medicine, sociology, immunology, economy, international relations, among many others. So interpreting the interpretation of the Constitution is not only a matter of textual and contextual analysis. And since the necessity tests imply assessing the effectiveness of competing means to foster fundamental rights, we must know how these means work and which are or may be their effects. So the result of the necessity test frequently, very frequently, depends on empirical considerations. Of all the stages, of all the three stages of the proportionality test, the necessity test is not only the one that more clearly interacts and respects the political process, it also is the one that more clearly and intensively considers knowledge from other sciences. I will say that, especially in times such as these in which we are living now, considering scientific knowledge is a feature that cannot be underestimated. Actually, as a matter of fact, it is almost a revolutionary feature. Ignoring or downplaying the role of the necessity test leaves less room for science in constitutional adjudication. Of course, we should not be naive about science. Disagreement on methods and outcomes are also frequent in hard science, as they are also frequent in social science. So even comparisons that can be made inside the lab may deliver different results depending on the methods. But although this is true, although empirical knowledge are very welcome within the necessity test, we should not think and expect that empirical scientific knowledge is all that matters. It is not, but it is very welcome. So we should not downplay the role of science, but we should also not be naive about science. So, and now I would like to conclude with something different here. And as I said, the title of the article in which my presentation is based is Standing in the Shadows of Balancing. This title was inspired by the title of biography of a bass player, Motown bass player called James Jamerson. The book is called Standing in the Shadows of Motown, The Life and Music of Legendary Bassist James Jamerson. And the title of this biography is also a reference to a song called Standing in the Shadows of Love, recorded by the Four Tops in 1967, with James Jamerson on the bass, of course. So I would like to conclude with an allegory from the world of music. When you listen to rock or a pop song, do you even notice that someone is playing the bass? You probably don't. But you surely pay attention to guitar riffs and solos. If you ever consider or imagine be a rock star as a kid, you must probably consider learning playing the guitar. This is understandable because the chances of becoming a rock star playing the bass are really, really small, unless you are Paul McCartney or you are Sting. Bass is not glamorous. Guitar is glamorous. A bass player usually stands in the shadow, but he or she provides a solid base for the guitar player to play yet another of his or her endless and sometimes boring solos. Something similar applies to necessity and balancing, I think. The necessity test has barely received attention of constitutional scholars so far, even of those who studied the proportionality test, with the exceptions I already mentioned. It seems that the necessity test is not glamorous at all. Balancing is glamorous. So those who want to be a star should definitely write a paper on balancing, not on the necessity test. But you should know, you must be aware that just as there is no rock song without a bass line, but lots of them without a guitar, there can barely be proportionality without the necessity test, but there may be proportionality without balancing. Thank you very much for your attention, and I hope we have time to discuss. Thank you very much.
Muchísimas gracias, profesor Da Silva. Hay un montón de inquietud y hay muchísimas preguntas en relación con su propuesta, sobre todo en perspectiva de lo que hemos visto esta semana y de lo que propuso en la presentación de ayer del profesor Vilchitz. Tenemos unos 20 minutos para preguntas, entonces para optimizar, lo que le propongo es que hagamos 2 rondas con varias preguntas y vemos cómo vamos de tiempo. ¿Sí? Y si nos queda tiempo, pues hacemos una tercera ronda. El primer,
muy bien.
El primer ciclo de preguntas, para presentarlas, digamos, de una manera general, se refieren o se cuestionan si lo que se ha evidenciado durante esta semana en relación con el test de necesidad, no es como un afán de volver al bajista el guitarrista, ¿no? Es claro, digamos, de lo que ha pasado en esta semana, que hay una presentación sobre ponderación que se ocupa exclusivamente de eso, pero hay dos que hablan explícitamente del bajista, que dicen que lo que hace el bajista es fundamental y que le hemos estado prestando demasiada atención a la guitarra. Entonces, hay digamos, este primer grupo de preguntas es más para que usted nos explique un poco por qué cree que eso está pasando, ¿no? Si es un fenómeno como de evolución, no sé si llamarlo natural, pero de cambio natural de los métodos de adjudicación, de refinamiento de la herramienta, o también puede ser una cosa que pasa en ciertos contextos de aplicación del test, ¿no? Que no es una cuestión que se pueda generalizar, sino que habría que ver qué es lo que está pasando en las diferentes judicaturas pues, de los países. Entonces, es esa como la primera inquietud general. La segunda también es más como expositiva, de si usted podría precisar cuáles son esas diferencias, qué es lo que hace que la propuesta de Vilchitz y la propuesta de Da Silva sean diferentes, ¿no? Y a estas dos diferentes de la propuesta canónica. Alguien nos dice, digamos, lo que se dice de manera recurrente del test de necesidad es que es una evaluación de tipo paretiano, ¿no? ¿Por qué su propuesta o la propuesta de Vilchitz serían una evaluación de tipo paretiano o no? También preguntan si usted conoce la decisión de la que habló ayer Vilchitz, ¿no? La decisión de la India, que parece que usa su modelo, que lo incorpora para tomar una decisión. Entonces le preguntan si conoce la decisión y cómo le parece, cómo le parece el uso del test de necesidad en ese caso concreto. Y una también ya para finalizar esta primera ronda es que como que la gente o los operadores judiciales, los estudiantes cuando les enseñan esto, los académicos, están acostumbrados más a ver números en la etapa de proporcionalidad. Pero aquí, toda esta pregunta sobre si los números aplican, son adecuados para determinar realización o restricción, se nos pasa a la etapa de necesidad. Entonces, la pregunta general es ¿por qué es adecuado medir realización en términos numéricos, ¿no? Asignar ese tipo de escalas? Y si los jueces tienen la formación para hacer esto, ¿no? Entonces, ya, digamos, además de todas estas exigencias en relación con la escogencia de cuál es la mejor, por ejemplo, explicación científica en relación con algún derecho. Además de eso, parece que tendrían que ser expertos en traducción de eso en términos numéricos, y si eso no es como esperar demasiado, y no solo esperar demasiado, sino exigir lo imposible. Ese es el primer gran bloque de preguntas.
Muy bien. ¿Debo contestar en español o en inglés o es lo
en
mismo?
Inglés, como se sienta más cómodo, pero creo que en inglés está bien. No ha habido problema con eso.
Okay. So, why we need to pay attention to the bass player, and why we have two presentations on the necessity test in such a conference, and only one maybe on balancing, or specifically on balancing. What is the reason behind this? I think this was the question. Is this correct? This is a good question. Actually, all of them are very good. So I'm not sure if I'm able to identify one reason. There may be a couple of reasons. One of them and this is not my reason, but I think it may be one of them, is a kind of reaction to objections that are made against balancing. So these objections are: balancing is subjective, is irrational, is dangerous, is courts can do anything with balancing. Balancing is a kind of magic. These objections led the supporters of the proportionality test, I think, to do two different things. One thing is try to make balancing as rational as possible, and then use numbers and formulas, etc. You all know this. And a second movement is, so okay, maybe is balancing not rational enough, so let's pay attention to the necessity test, because necessity test is science, it's empirical knowledge, so this is what we need. This is, everyone agrees when science says that this is correct. So I think one of the reasons may be this attempt to escape the objections against balancing. So forget a little bit balancing, let's pay attention to the necessity test. And look at Canada. In Canada, the necessity test is very important, and they almost don't need balancing. So this is great. I don't think this is a good answer, but I think this may be an answer. Why I think, or the reason why I wrote a paper on the necessity test was just to highlight its strength and to show that even if most cases passed the necessity test and will be decided on the balancing stage, the necessity test has a role to play. I don't want to exaggerate this role. As someone said, I don't want to turn the necessity test from bass to guitar. This is the bass. The bass, we know it's important, but it's not glamorous, etc. So, but let's recognize how important it is, and let's define its role properly. And something that was that bothered me a lot was to read papers and books on proportionality and to find nothing on the necessity test. So it was an attempt to show the necessity test has a role to play. What is the difference between my approach and David Bilchett's approach? It's a good question. In a way, they seem very similar, and because I say, well, even a slightly less efficient means should be considered in the necessity test, and David actually says the same, but I think he goes a little bit further. He said, well, it's not only that I should take into consideration means that are slightly less efficient. I should take slightly less efficient means into consideration if this, or not only slightly less, but even fairly less restrictive, if this is compensated by less restriction. So this is balancing. And I don't think that balance should take place in the necessity test. So if you say this is the means adopted by the legislature, and I have an alternative means, it's not only slightly less efficient, it's actually fairly less efficient. And I would say, so this is not an alternative. Even if you argue, but listen to me, it's also really less restrictive. And I say, I don't care. If it's fairly less restrictive, is not equal, not even approximative equal, so it's not an alternative. So the first part is similar. We reject strict necessity or strict equality, but David goes a little bit further and say we should make an overall comparison and balance. And I think, no, we shouldn't. Because if we do this, we won't respect the priorities defined by the political powers. So if I want to, for instance, if I want to realize health and education to a very high degree, you cannot argue, well, I have an alternative. It's not that effective, but it's also cheaper. So no, this is not an alternative. You should respect my priorities. I was elected to put forward a plan to foster health and education. So don't balance this against your own priorities. This is the difference. And I say my proposal is much more, much less ambitious. And I don't think that, I think my proposal is still compatible with the idea of Pareto rationality. And I think that David Bilchett's proposal is not Pareto anymore. It's maybe Calder-Hicks and so on, but it's not Pareto anymore. I'm sticking to Pareto. So I think Pareto should be maintained. It's only, I think we should be a little less strict and to decide what means to be equally effective. I don't know the details of the decision of the Supreme Court of India, so I cannot really comment on this. I'm sorry, I'm really sorry. And the numbers. Why use numbers? As I said, the use of numbers became popular as a way to say, well, see, balancing is very rational. We could just do the math. I don't think so. I don't think so. I use numbers today only to illustrate, but it's only an illustration. I think numbers can be misleading sometimes and can make things more complicated, and formulas can make things more complicated. And I think we should make things easier, less complicated. So I only use numbers to illustrate. I don't think that we should add or divide or multiplicate, nothing of this sort, neither in the necessity test nor in balancing. And finally, the idea that the necessity test demands empirical and scientific knowledge. We say, well, I studied law, we all here studied law, and we have no idea on computer science, medicine, genetics, virology, etc. Yes, this is true, but I think the court, especially a Supreme Court or a constitutional court, should demand, should use the knowledge from people that possess this knowledge. And of course, again, we should not be naive about science, because I say, well, let's decide about compulsory vaccination for COVID. Should vaccination be compulsory or not? And the legislature said, yes, it should. Of course, I can ask two virologists, and they say, what the first one say, yes, this is the best way, and the second said, no, it's not. So there is disagreement in science as well as in law. But I think that the court should attempt to be informed, and this is of course very complicated. This is also a reason why many people say, well, forget the necessity test. It's too complicated. It demands too much, and we are not able to do it. Forget it. I think we are able to do a little bit, yes.
Perfecto, muy bien. Muchas gracias por esas respuestas tan concretas y tan completas. Se nos está acabando el tiempo, entonces creo que la segunda ronda ambiciosa que iba a hacer se va a volver una ronda más bien deficitaria. Pero y solo quiero decir una cosa, el profesor Borowski estuvo hace un par de años en el seminario sobre metodologías que hace el Centro de Estudios Constitucionales. Y el texto que él presentó fue sobre una versión Calder-Hicks del test de necesidad. Entonces, sí hay como cierto ánimo de volver al bajista guitarrista. Sí, parece que las cosas se están moviendo para allá.
Ojalá.
como que resonó mucho esta metáfora musical. Y lo que preguntan un par de personas es si el nuevo bajista no es la etapa de idoneidad. ¿Mm? La idoneidad parece que es el momento en el cual todo este debate probatorio se da por primera vez, ¿no? Y todas las complejidades de la prueba en el derecho, la prueba científica y bueno, todo el universo de cosas que están ahí, que pues, tú conoces muy bien, parece que se dejan de lado. Entonces, idoneidad es un problema de causalidad, como si la causalidad y la prueba de si una cosa sirve para otra fuera fácil. Aquí no hay mucho que hacer. Entonces, idoneidad la dejamos como de lado. Y parece que ahí es donde empieza, ahí es donde se plantean los términos del debate probatorio, ¿no? Porque es donde se establece con qué es lo que se va a comparar, ¿no? Y es tal vez lo que determina cuáles son las alternativas razonables de comparación ya en el test de necesidad. Y la segunda es, la segunda pregunta que alguien plantea que me parece interesante es ¿por qué seguirlo llamando de necesidad si parece que aquí lo que nos estamos preguntando no es si es necesario, sino si es razonable, si es posible, si es admisible? Parece que la necesidad, bien sea lógica, pragmática o de otro tipo, es una exigencia bien estricta en relación con las medidas y si logra los fines que se propone, cuando parece que tu propuesta en específico lo que está haciendo es relajándole la necesidad a la necesidad. Si eso tiene algún sentido. Y hay un montón de preguntas más sobre la posibilidad de que con la deferencia que tú planteas, los derechos sociales nunca pasen, ¿perdón?
Solo algo, por mí, no sé si tiene que encerrar por mí podemos debatir más, yo no tengo problema, pero tal vez tengan usted, pero podemos debatir por más 10, 15 minutos, no tengo problema ningún.
Perfecto,
Usted decide.
muchísimas gracias. Entonces déjame plantear la última, así que es como de las gruesas que reúne además varias inquietudes. Y es que parece que el test que defiende Vilchitz como que fortalece la posibilidad de proteger derechos sociales fundamentales por parte de las Cortes, ¿no? Porque la cuestión con derechos sociales es que generalmente está disponible el argumento de progresividad. Entonces, medidas más alternativas, un poco menos eficientes, pero que logren, siempre va a haber como la posibilidad de defender la decisión tomada bien por el gobierno o bien por el legislativo. Entonces, la tutela de derechos sociales fundamentales parece que se ve disminuida o es menos probable con este tipo de propuestas como la tuya. Y ayer también, perdón que siga haciendo referencia, pero la gente está como dándole vueltas a tu propuesta y a la de Vilchitz. Y es que ayer Vilchitz decía que él creía, pero no lo elaboró mucho, que las obligaciones positivas no se llevaban bien con el test de necesidad, ¿no? No expuso mucho más que eso y te preguntan, ¿tú también crees eso? ¿Crees que la manera de plantearse estos problemas del test de necesidad es combinar métodos de decisión judicial y si esto no hace la decisión judicial ya, al menos en la etapa de necesidad, todavía más complicada? Y con esas creo que tenemos para un rato más.
Okay, thank you. And again, I'm really sorry about the time. I know we started late, and I was the full screen. I wasn't able to control my time. I should have a watch, but I'm really sorry. And if you want, I can stay longer. No problem at all. So that means we can have another group of questions if you want. It's interesting that always whenever I present this paper on necessity, people also asked about the suitability and say, well, and and they also associate the music allegory to the suitability test. Sometimes they ask, well, if balancing is guitar and necessity is the bass, what instrument is the suitability test? I don't know. I still haven't decided about it. But I think the suitability and necessity tests, actually they should be assessed together, not together in the sense that there is only one test. There are different tests. So the suitability test is not there is no comparison. It's a means end analysis, and the necessity test is a comparative test. So they are different, but they have lots of similarities, much more between both than with the balancing test. So I don't know if the suitability test is the base. I think I like the necessity test and I like the base, so that's why I chose the base to be the necessity test. But I think that the suitability test is also downplayed. There are lots of people say, well, this is useless. If necessity is almost useless, suitability is really useless. I don't think so. And of course, we can also discuss what does it mean to be suitable, because I can have a version of the test that is really not ambitious at all and say, well, almost everything is suitable if it fosters a little bit the goal. And yeah, I can have a more ambitious version, say, well, okay, a little, almost nothing. It's not suitable at all. But I still want to write something about the suitability test. I think there's lots to discover there, and I don't know. Actually, I don't think I know any paper at all that deals only with the suitability test. So I think this is something that should be done. Even if in the end we say, well, actually, yes, it's more complicated than we thought, but it's not really useful as we expect. The outcome is not really important, but I think we should pay more attention to it. Why? I'm not sure if I understood correctly the question. Why calling the necessity test? Why? Well, it's not necessary. The necessity that it's implied by the necessity test is not the idea, the general idea that we have about necessity, in the sense that something is necessary if it has to be done. And this is not the case. It's a question of political opportunity. If we do this, if we choose these means or not, it's not that it's necessary as such. And more important, I say, usually when we say, well, it's something must be done, we also imply that this is the right solution and is the best solution for the case. And I think that's one important hypothesis of my paper, is there is no such thing as the best solution. So it's maybe the case that necessary is not the best term, and actually in German there are two words for necessary, and usually in the common usage we used one of them, and in the necessity test, in the proportionality test, we use another one. It's a little bit different, but I'm not sure if I understood correctly the question, and I say that it's a confusion between the idea of necessity and the idea of the necessity test, but I think it's in a way necessary. The idea of necessity is implied. So actually, let me rephrase it. I think it maybe is the idea of necessity that is implied is actually in the negative sense. If there is an alternative, then that means was not necessary. Well, I think that's my answer. If I didn't understand correctly, please let me know. And And the use of the necessity test in the context of social and socioeconomic rights, I think that proportionality in general it's much easier to apply to negative freedoms than to positive obligations. It's very complicated to use it in a positive obligation and socioeconomic rights. And there are also much less things written on this subject. One of the examples I use today is from the socioeconomic rights, healthcare and education. But I think it's much more. I don't think it's impossible to use the necessity test and the proportionality test for socioeconomic rights, but it's much more complex than to negative rights. I know this is something everyone knows, but there are people saying, well, we can't use proportionality in socioeconomic rights. I think we can, but the results are maybe less clear than in the case of freedom rights. And I would like to say something very, if I may, I don't know. Okay, the idea, something that David said yesterday when he compared the time that information may be kept, 3 years or 6 years. So of course, 3 years is not as efficient as 6 years, and we can say 9 years is even more effective, and 12 years is even more effective, and so on. I don't think this is true. There's a very good example that this may be false in some contexts, and this is the speed limit in streets in a city. So suppose that the speed limit in the streets in proportionality city is 30 kilometers per hour, and 30 kilometers per hour, just as every driving cars are may always be dangerous. So people may get hit by cars and be injured and even die. And then we decide to raise the speed limit to 50 kilometers. And then we say, well, why 50 and why not 40, or even why not keep in 30? And then we say, because 50 is more effective to foster mobility. And so you cannot propose to keep it in 30 or raise to 40 because, well, it's not as efficient. And actually, it is just as efficient. There are lots of research that shows that if we raise the speed limit, the gains in mobility is almost negligible, because in a city there are crossing and lights. So everyone knows if two cars started together and one of them drives at 30 kilometers and the other 50 kilometers, of course, the one that's driving 50 kilometers is faster, and then they will meet in the next traffic light. And then they always meet in the next traffic light. So the car there is driving 50 kilometers maybe arrived 2 seconds earlier. So there is no gain in mobility, although I'm comparing 30 kilometers and 50 kilometers. And the risks to be injured is much higher at 50 kilometers than 30 kilometers. So comparing numbers, sometimes we think, well, 6 is better than 3. I don't know. Maybe it's the same thing. Maybe I don't have any benefits of keeping data 3 years longer. And I say, well, 6 years, 4 years is just as effective. So I think that we should be numbers are sometimes very tricky, and that's why we should be aware and be careful when using them when we are doing legal reasoning. So I'm not sure if I answered everything. all the questions. And again, if you have more questions, I'm here. Just.
Muchísimas gracias. Creo que de hecho estas respuestas que nos acabas de dar como que cubren buena parte del pool de preguntas que quedaba. Entonces, solo me resta darte las gracias de nuevo.
I want to thank you again for this wonderful conference and this conversation with us, and for calling our attention to points that go unnoticed with respect to the test in general and with the necessity. And we hope to read your paper soon. We hope to read your essay in the icon and go back to it in another event. So for all the people who attended from our social media and our platform, thank you very much for your questions and for being with us during this week. Also, I thank all the staff of the Supreme Court involved in making this event possible and the work. Well, sometimes you don't see this work, but it is necessary for this to take place. People from the legal house, IT, social media, of course, the staff of the Constitutional Studies Center. The table will be great. We have David Duarte from the Portugal University, who will talk about the positivist or the positivist foundation of the proportionality test. And another colleague will talk about how this methodology has been implemented in the Greek reality. So we'll see you at 11 on Monday. I hope you enjoy your weekend. Thank you very much.